Ladies and gentlemen, we are here under case docket ending 2012-2013, Samantha Somerville and Sidney Kirsch versus Olympus State University. Are petitioners ready to proceed? Yeah. Respondents ready to proceed? Mr. Cremery, the floor is yours. Is it Crenery? I'm sorry. Anytime you're ready.
Good afternoon, Your Honors, and may it please the Court. My name is Gianni Crameri, and I represent Samantha Somerville. For the next 9 minutes, I will demonstrate that OSU's affirmative action program violates the Equal Protection Clause of the 14th Amendment. My co-counsel, William Manning, will demonstrate for 8 minutes that OSU did violate Sidney Kirsch's First Amendment rights. My argument is based on 2 grounds. First, OSU's affirmative action program does not constitute an important government interest. And second, affirmative action program is also not substantially related to achieve an important government interest. Therefore, my clients ask this court to reverse the decision of the lower court.
Let's talk about your first point, the important government interest. I thought we said in Grutter and Parents Involved versus Seattle School District that achieving diversity is a compelling state interest. Can you explain to me why the important government interest is missing here?
Yes, Your Honor. In Grutter, this court, as you correctly said, is achieving diversity. However, in this case, we believe that OSU has already achieved a diverse student body in respect to gender, because in Grutter, this court said that the definition of critical mass is numbers such that underrepresented minority students do not feel isolated or like spokespersons for their gender. With 36...
Are you saying 36% of men they would feel abandoned or insubstantial?
No, Your Honor. We would say that they do not feel isolated or do not feel like spokespersons for their gender. We believe that 36% is enough for them to not meet the definition of establishing Grutter for critical mass. Moreover, in Virginia, this court has stated that if VMI would achieve 10% of female enrollment, it would be a sufficient critical mass to provide the females with a positive educational experience.
Yes, but once again, in U.S. versus Virginia, we're dealing with VMI, which was traditionally an all-male institution. There's no indication in this record that OSU has ever been an all-female institution. So why wouldn't it make sense for us to allow the critical mass to be higher given the OSU's co-ed history?
Your Honor, again, I have to refer to the definition in Grutter, which says that underrepresented minority students do not have to feel isolated or like spokespersons for their gender. We do not see any evidence in this case that this is present on OSU, that this is happening on OSU's campus. In Adderant, this court has said that because racial preferences are perceived by many as resting on the assumption that the students that had an advantage because of racial preferences are less qualified in some respect, it hurts the supposed beneficiaries of the affirmative action program. And this can be clearly seen in this case. Males are admitted with far inferior academic credentials than any female student. And therefore, that males are being perceived by many, not just by the females, but by generally all people, that they are less qualified, and therefore it would hurt them.
Well, what would you say to the argument, though, that men provide a unique world perspective which contributes to OSU's diversity in a way that female candidates cannot?
Yes, Your Honor. Every different backgrounds bring different experience into the classroom. However, we believe that 36% is enough to constitute the necessary quantity of these diverse backgrounds or experience, and therefore we believe that OSU does not need to increase diversity.
Are you saying that basically, so long as the critical mass is achieved, that a university can never attempt to elicit more diverse candidates?
Your Honor, diversity is always going to be a benefit. However, in respect to gender, in this case, we believe that gender are appropriately represented on OSU's campus.
Counsel, isn't there a better overall college experience with a better balance of diversity on campus?
Yes, Your Honor. That was the reason why in Grutter the court upheld Michigan Law School affirmative action. But in this case, the affirmative action program was tailored to let minority students in, so majority students are exposed to the views that these minority students bring. In this case, we have gender. It is unlikely that any female person has not experienced a male perspective in their lifetime. Females are always exposed to male perspectives.
What about a female that has always attended all-female schools?
Yes, Your Honor, but that would be an extreme case. It cannot be compared with race. In race, it is more likely that a majority person will grow up without any involvement with minority people.
Who are we to say that? Who are we to say though that we can tell a university, hey, people are exposed to that minority group, you can't discriminate against them? Who are we to tell them that?
I'm not saying that you have to tell them. However, I'm saying that in Grutter, the reason why diversity was important is because the minority students brought experiences into the classroom that the majority students were generally not exposed to. And OSU believes that, the petitioner believes that that females are already exposed to males and had enough exposure to males to already benefit from their experiences.
As I understand your argument, you're saying that we should, the intermediate scrutiny test applies here. However, you keep referring back to, as opposed to strict scrutiny, but you keep referring back to race cases where strict scrutiny was applied. So maybe you can explain for this court why the race cases should be analogous here to a gender case, which you're admittedly, in your opening statement, are saying that shouldn't be applied to the same level of scrutiny.
Yes, yes, Your Honor. In Hogan and Virginia, this court has established that discrimination based on gender for this discrimination, an intermediate scrutiny has to be applied, and therefore that's why we believe that intermediate scrutiny is the appropriate balancing test. However, if this court would apply strict scrutiny, we would still meet because we show a clear differentiation between the Grutter case and the case at bar. To get to my second point, which is that OSU's affirmative action program is not substantially related to achieving an important government interest. OSU fails to say what a critical mass would look like to have a diverse student body.
Weren't there a series of factors that the school looked at? I mean, this is not exactly like Bakke, where it was unconstitutional because they were looking at a quota and they were only deciding specifically on race. Here there's several factors, including socioeconomic status, whether they were a single parent.
Yes, Your Honor. Even though this court can be distinguished from Gratz, however, it can also be distinguished from Grutter. In Grutter, non-minority applicants were accepted with far inferior academic records. And in this case, there were males accepted with inferior academic records, however, no females were accepted with inferior academic records as indicated in the record. And therefore, we believe that this is not the case. Therefore, even though they do not have a quota, we believe it can be distinguished from Grutter and it is not substantially related. And further, in Bakke, this court has said that race can be a plus factor. In this case, however, we believe that gender was not simply a plus factor, but the deciding factor.
Counsel, let's say that we disagree with you that Olympus has an important government interest, but the question then relies on whether it's substantially related. Don't the facts indicate that OSU tried several alternatives before this program with baseball caps and tickets and recruiting people from men's particularized aspects of society that were dominated by men to increase the male presence? Doesn't it indicate to you that OSU has tried alternatives but just could not seek one before this?
Yes, Your Honor. I see that my time is running short, so can I answer your question? In Grutter, this court established that a university has to do a good faith effort and provide race-neutral alternatives. In this case, OSU did provide alternatives. However, they were not gender-neutral. They were based on stereotypes and therefore not valid under the principles established in Grutter. Thank you, Your Honors.
Thank you, Mr. Vermeulen.
Good afternoon, opposing counsel, your honors, and may it please the court. My name is William Manning, and I represent Sidney Kirsch in the case at bar. My colleague just demonstrated that OSU violated Samantha Somerville's 14th Amendment rights, and I will show that OSU violated Sidney Kirsch's First Amendment rights of free association. My argument is based on two grounds. First, that the university does not meet the standard of review established by this court in a limited public forum, and second, that the university is engaging in viewpoint suppression. If the court turns its attention to the Christian Legal Society case, in this case, the court established that a university is a limited public forum. And the standard of review for this forum is that they must have a compelling and viewpoint neutral policy.
Just to be clear, Christian Legal Society stated that certain parts of a university are a limited public forum. Are you arguing that the entire university is, or just certain parts of it?
Your Honor, we are arguing that the parts of the university pertinent in the record to this case are a limited public forum. Additionally, in the Christian Legal Society case, this court established that in order for an organization to force another organization to accept members it does not wish to accept, it must use a policy of close scrutiny. And in that standard of review, the university must have a compelling state interest, and the policy itself must not suppress the ideas of the organization that it is directed at. Now, if we look at the case at bar, in regards to a limited public forum, first, a viewpoint neutral policy was established by the court as an all-comers policy, being a textbook example. In the case at bar, the university has a textbook example of a viewpoint neutral policy.
Isn't the close scrutiny standard limited to speakers who fall within the class to which the limited public forum was opened? Why couldn't OSU make the argument, yes, you get close scrutiny if you follow the guidelines of our anti-discrimination policy. You don't, all you get is reasonable review.
No, Your Honor. In regards to the case at bar, the university does have a limited public forum. However, they do not meet the standards established in order to regulate a group. If the court decides to apply close scrutiny or even a level of strict scrutiny in the case at bar, we will also show that OSU does not meet those standards as well and cannot force WTE to accept members which it believes will fundamentally change the message they espouse. In the Christian Legal Society case, the court stated that if...
I thought the men who wanted to join WTE were trying to further the same interest of the woman, which is to oppose the program.
No, Your Honor. If we look at the record, it is demonstrated in the WTE Constitution on pages 5 and 6 that the group itself does not stand to oppose the OSU policy, but they instead stand to further women in leadership. In the Constitution, it's worded as that men have dominated leadership at the university.
It says in their Constitution that they would disband if the program was terminated.
No, Your Honor. It says they would consider disbanding, and the reason is that the problems in male leadership at the university are what caused the program to be created. The organization believes...
Hold on, because, I mean, it does seem to me that the primary mission of this advocacy group is to advocate against the policy that they're objecting to. Is that not the case?
Yes, Your Honor, that is one of the main focuses of the group. However,
isn't that, in fact, the primary mission of the group?
No, Your Honor. The primary mission is that males have dominated the leadership at the university and the outside world.
But hang on. I mean, is there any evidence in the record, for example, that it was only men who decided that there should be, that the policy that basically the WTE group is objecting to? I mean, that was created by the university, correct? And the university is made up of both men and women in their leadership position, correct?
No, Your Honor. If we look at the record, it demonstrates that the Dean of Admissions is a male, and he sought to enact the program. This was not a decision he made in a panel, but he decided that the problems at the university were such that they needed to be addressed.
But does the record indicate that he didn't receive any input from any of the other...
Your Honor, the record indicates that he instructed the policy to be created to address the gap. It states that he instructed a subordinate to create the policy to help fix the gender gap. It does not state he consulted with anyone or if he did not consult with anyone. So the record is not clear.
But for example, it's not part of the agenda of the WTE to have this dean dismissed, correct?
No, Your Honor. It is their position that women need a higher percentage of leadership roles, because if women had more leadership roles in both the organization and society itself, they could advocate the women's perspective, such in this case that...
Okay, but let me stop you again, so sorry, but I mean, granted, let's assume for the sake of argument that you're correct, that the WTE, that one of its missions, whether it's the core mission or just one of the missions, is to have women in leadership roles. Now, to have men join the group, but not necessarily in leadership roles, how does that in any way detract from the mission of the WTE group?
Your Honor, in the cases of Hurley and Boy Scouts, this court established that if an organization is forced to accept members which would fundamentally change their core values, that the group could deny them access to the organization.
Well, counsel, then doesn't this create a slippery slope? Are you saying that WTE could discriminate against minorities?
No, Your Honor, and for two reasons. If we look at the record, it demonstrates that WTE said it was fully willing to meet the student recognition policy that they should not be discriminatory in all other instances except for males, demonstrating that males would fundamentally change their values. Additionally, Your Honor, in the case at bar, it is comparable to Boy Scouts and Hurley because those cases, it was not even explicitly stated in either group's core values that homosexuals would change their views or change the events which they were holding.
But counsel, I do see a distinction between both Hurley and the Boy Scouts case and the case that we have here, because what's clear in both the Boy Scouts case and the Hurley case is that the inclusion of this group would actually change the message of the group, because the group had a specific message in the case of the Boy Scouts, well, actually, really in the case of both organizations, that was, you know, an anti-message essentially. But here we have men who want to join, who are very much in favor of the values of the WTE. The gay pride marchers who wanted to join the South Boston parade definitely wanted the parade to say something more than it was saying at the time. The gay scoutmaster who wanted to join the Boy Scouts definitely wanted the Boy Scouts to be more inclusive than they were at the time. So isn't there a distinction between those two cases and what we have here?
No, Your Honor. To begin, in the Boy Scouts case, the scoutmaster did actually not espouse his views to any of the scouts. He was merely excluded from the group because he was homosexual. He did not share these views, and when the Boy Scouts found out, he was removed.
Let's say we agree with you that Boy Scouts is the controlling authority on this. Correct me if I'm wrong. Boy Scouts stands for the proposition that the state must show strict scrutiny to alter a group's message for an expressive activity. Who's to say that the context of education does not provide a compelling state interest to justify this change in the group's message, in the furtherance of the anti-discrimination policy?
Your Honor, if the court applies strict scrutiny, the university may use strict scrutiny and have a compelling state interest, but as established in Christian legal society, that cannot suppress the views shared by the group. If we turn to page 7 of the record, Dean Comerford stated to Kirsch herself that she did not cease promoting her organization, she would face discipline, and shortly thereafter she was expelled. May I briefly conclude, Your Honor?
Yes, briefly, please.
And further, the dean did not ask her to accept males to change the policy they had, but instead to stop promoting their image. For these reasons, we ask the court to reverse. Thank you.
Thank you, Mr. Manning. Ms. Freeman.
Mr. Chief Justice, Your Honors, and may it please the court. My name is Michelle Freeman, and I, along with co-counsel Jacob Gomez, represent the respondent, Olympus State University, in this case. In my time before you today, I will discuss the 14th Amendment issue. My co-counsel will discuss the first. The question before the court is whether Olympus State University's admissions program violates the Equal Protection Clause of the 14th Amendment. It does not, and we urge this court to uphold the lower court's judgment for the following 3 reasons. First, the intermediate tier of scrutiny is appropriate in the case at bar. Second, Olympus State University's admissions program falls inside the parameters that this court has held acceptable in affirmative action programs. And third, to reverse the lower court's judgment would hamper the ability of the universities to choose a diverse student population. Now, before I begin my argument, Your Honors, I would like to discuss a point the petitioner raised. Petitioner twice defined critical mass, as cited in Grutter versus Bollinger, as one that makes individuals not feel isolated, nor tokens or spokespersons for their group. However, this definition came from the respondent's brief in that case, and the court rejected it, stating that in leaving the definition of of critical mass open, for the court realized, as discussed in Sweeney versus New Hampshire, as cited in UC Regents versus Bakke, that one of the essential freedoms of the university is to choose its student population.
Did a majority of this court, and because there was no majority, did a majority of this court endorse the Sweezy quote which you've just described?
Yes, Your Honor, they did. And this turns to the intermediate tier. We agree with petitioner that the intermediate tier is appropriate in the case at bar, and therefore the government or Olympus State University must only show an important governmental interest.
But let me stop for a moment, because you brought up the issue of the critical mass. And it does seem to me that if you have, I think it is 36% of the student body, something like 5,400 students, that feels like a critical mass to me. I mean, how is that a group that doesn't have the ability to have their voice be heard?
Perhaps, Your Honor, but respondent is hesitant to assign a number to a critical mass, for it would be in contrast with this court's jurisprudence in which it has moved away from numbers as a quota.
That's fine. I'm not asking you to assign a number, but what I would ask you to tell me is conceptually, how do we get to critical mass in this case, right? I mean, let's just get the arguments mixed up, but never mind. So, in any case, OSU is arguing that you don't have a critical mass, correct?
Yes, Your Honor.
And if you got to 50-50, presumably you would have a critical mass, right?
Perhaps, Your Honor, and the court did hold that a university can have a goal allotting the Harvard plan in Grutter versus Bollinger.
Okay, but so my question is this. I don't want you to assign a number between 36 to 50%, but I want you to distinguish for me, when do we get to critical mass in that number between 36 and 50%? What is it that gets us to the critical mass?
Your Honor, we see that a critical mass is, the court has acknowledged, is when you know it when you see it, and it is the ability and the responsibility of Olympus State University to determine when that is, for it is an essential freedom of the university to choose.
In that case, isn't it basically a quota system? And your client, the university, was kind of marketing, advertising toward just men. They just wanted men at their school to raise the gender quota here.
Respondent respectfully disagrees, Your Honor, and then while the university did reach out to males in the forms of baseball hats and baseball tickets, they also offered campus tours and application programs. They were seeking a male population, which is an important governmental interest in order to maintain diversity. This court has held diversity to be a compelling state interest in a series of cases, starting with...
Well, that might be true. Ms. Somerville had clearly superior credentials when she was applying to OSU. She had a high GPA, 2,100 done her SATs. She was involved in several groups, and male counterparts were being admitted with far less credentials.
Yes, Your Honor, and undoubtedly Ms. Samantha Somerville was an academically qualified student for Olympus State University. However, Olympus State University does enact its affirmative action program within the guidelines of this court, and there is 3 evaluating factors that this court should look at, outlined in Grutter versus Bollinger. First being whether an individualized review has taken place. Second, whether there is a quota system involved. And third, whether there is a long-term provision. Turning to the...
But so let me ask you there. I mean, it seems like the remedy that the university adopted is pretty drastic. And in addition, it does seem like that what the university did in making such a discrepancy, basically, between the numerical grade point averages and the numerical SAT scores and so on, that I see that as potentially being a charade, where what they're really doing is they're simply adding points, but we're saying, well, we're looking at it holistically, but because they know that's what the courts have required, but that in effect this really is a virtual point adding system.
Respondent respectfully disagrees, and we can look to the record and see that Olympus State University does provide an individualized review as well, and takes into account hard factors such as GPA and SAT, as well as soft variables. As the record lists, the university looked at whether people had started a business, had they been a single parent, whether they had traveled extensively, or they spoke a foreign language. These are all actions that only would add to the diversity at Olympus State University.
And we can all agree with that, but let me ask you this. If a man spoke a foreign language and had started a business, and a female applicant had spoke a foreign language and started a business, would those be evaluated equal?
Yes, Your Honor, and there is no two-track system such as that in UC Regents versus Bakke.
Okay, so then we must conclude from the facts, basically, that there was an overwhelming number of men who had much better soft factors than the comparable number of women.
Yes, Your Honor, the facts lead us to believe that men offered soft variables that Miss Samantha Somerville could not compete with. Further, we see that Olympus State University had no quota system. The use of gender and affirmative in Olympus State University's affirmative action program is much like the plus in Johnson versus Transportation Agency.
Hasn't your client conceded that gender was one of the predominant factors looked at in the application process?
Yes, Your Honor, the record does state that had Miss Samantha Somerville been a male, she would have been accepted to Olympus State University. However, we would urge this court to not hold that as dispositive. It could have easily said that had Miss Samantha Somerville spoken a foreign language, she would have been accepted to Olympus State University. This only demonstrates that Olympus State University does indeed use these soft factors and allows them...
Talk all day about the factors, and I want to move on to the discussion about the standard of review. OSU wants the intermediate scrutiny standard to apply.
Absolutely. Absolutely, Your Honor, and that is the court's standard for the past 40 years, beginning with Craig versus Bourne, as cited in Mississippi versus Hogan, in which the court abandoned its jurisprudence from that.
So what is the intermediate scrutiny standard then?
Yes, Your Honor, as petitioner asked for, they must demonstrate an important governmental interest that is substantially related to that interest.
So what is the important governmental interest here?
Undoubtedly, it is diversity, Your Honor, and this court has held diversity to be compelling. A fortiori, it is...
What is so good about having a diversity between the genders in a university? What's so good about that?
Yes, Your Honor, and the court did offer a definition of diversity in Grutter versus Bollinger, and that is one that diversifies the learning environment, that allows for the cross-gender understanding, the breaking down of stereotypes, and the introduction of new analytical approaches.
But let me ask you this. If one were cynical, could one not argue that the real thing that the university is trying to promote is its maintenance as one of the top universities? That what diversity, particularly gender diversity, will help to do is to leave it in that top tier. And isn't that in fact one of the things one can argue that that's what the university is really trying to do?
Perhaps, Your Honor, and Olympus State University did indeed set out to close the gender gap. However, they did so within this court's jurisprudence as deemed acceptable, for they were seeking a diverse student population.
Is your client sacrificing integrity in academics as a school for diversity?
Absolutely not, Your Honor. As we see, women with 3.8 GPAs and 2100 SAT scores are admitted to Olympus State University. However, hard variables are not indicative of how an individual will do once they arrive at a university. In fact, SAT scores many times do not predict a individual's success at a undergraduate university. That is why the court has upheld the use of soft variables, for it allows for a better understanding of each applicant and further allows for Olympus State University to maintain a diverse...
So why should we just defer to OSU? What I'm saying is, if there is a student who had every soft factor known to humankind, but had a GPA of 1.5 and an SAT of the minimum 600, is there a limit to which the university just has to say no?
Yes, Your Honor, and we see that Olympus State University did not admit any men with lower than a 3.0 GPA or a 1600 SAT score, which is a B average and is exceptional when applying to an undergraduate institution. We therefore see that Olympus State University does indeed fulfill the requirements that this court has held needed to be in an affirmative action program.
So let's get to the second point of your intermediate test about substantially related. How would you respond to the fact that this program's been in place, this policy's been in place for 5 years now, and they still have only a 36% male population? So, I mean, how is the policy substantially related to serving that important government interest, assuming we agree that it is in fact an important government interest?
Yes, I see that my time...
You may answer, please.
Your Honor, we can turn to the case of Johnson versus Transportation Agency, and you cited how it has been quite a few years that this affirmative action program has been in place. However, there is still a vast gender imbalance present at Olympus State University. This only demonstrates that Olympus State University is using the gradual case-by-case approach that this court held necessary in Johnson versus Transportation Agency. And it is for these reasons that we respectfully request that you uphold the 14th Circuit's judgment. Thank you, Your Honors.
Thank you, Ms. Freeman. Mr. Gomez.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Jacob Gomez, and I will be continuing arguments on behalf of the respondent in this case. The question before the court is whether the respondent's anti-discrimination policy, which ensures equality for all students within Olympus State University, violates the petitioner's right to free association, which is protected under the First Amendment to the United States Constitution. Your Honors, it most certainly does not, and therefore, as I will explain today, this court should affirm the ruling of the 14th Circuit Court for the following 3 reasons. First, the respondents have established a limited public forum within Olympus State University. Next, Women for True Equality's discriminatory practices contradict the very purpose of Olympus State University, and therefore are in violation of their expressive associational rights.
Well, let me stop you for a moment at the public forum, because I am interested in this part of the case. So, first of all, university campus in general is a limited public forum, correct?
Yes, Your Honor.
But there can be parts of a university campus which are more open as a public forum. And so, for example, here much of the activity took place at a coffee shop, correct?
Yes, Your Honor.
Now, is this coffee shop a coffee shop at which only students can appear?
Your Honor, the coffee shop is on the campus itself, and due to the fact that students are the ones usually let onto a campus, the record is silent to the fact if others have gone to this coffee shop, Your Honor.
Okay. So let's say for the sake of argument that I could go to the coffee shop even as a non-student and they would serve me coffee. They're not going to ID me. Let's assume that for the sake of the record. Wouldn't that then make the coffee shop an open public forum?
No, it would not, Your Honor, due to the fact that within the case at bar, we are speaking about an issue within a university and its students. In regards to the fact that in no way does the university's administration have any type of jurisdiction in regards to yourself as a private citizen, Your Honor.
Well, let me ask you this. Suppose we move the coffee shop off campus, just, across the street. Is it now an open public forum?
Yes, Your Honor, due to the fact that it is off the campus at this point in time, it's an open public forum in which people from the community as well as students may come and use the coffee shop. And this was the case within the case at bar, due to the fact that if Miss Sydney Kirsch had decided to use an off-campus type of area to meet, there would have been no situation in regards to the discrimination within the campus, Your Honor.
Then, so just to finish the point, so is your argument that just the mere fact of moving the coffee shop from off-campus to on-campus makes this now a limited public forum?
Yes, Your Honor, it does.
Okay.
Let's talk about, I'd like to ask you about the expressive association argument, your second point, with respect to the university. And when I ask that question, I'm being cognizant of New York City Club Association, a statute which created an exception for clubs with, I believe, fewer than 400 members. This is a university which, I'm not sure the facts specifically state this, but the accepted class of students, 1 year's worth, is 2,250. Couldn't you make the argument that this university is so large that it should not be conferred expressive association status under the First Amendment?
No, Your Honor, we would respectfully disagree as the respondents due to the fact that within the case of Pleasant Grove City versus Summum, cited within Christian Legal Society versus Martinez within footnote 11, it specifically states that a government entity, which in this case is construed as the university itself, they may have a message to express, and that is protected, Your Honors. And with that being said, the forced inclusion of the group Women for True Equality alters the message as well as creates a new message.
Why isn't this like Rumsfeld? We're not asking the university to affirmatively espouse the views of the group. All we're asking is for an opportunity, all the group is asking for is an opportunity to be on campus, much like military recruiters.
Absolutely, Your Honor. I can answer your question in 2 parts. The first part being the fact that in regards to the characteristics of the case itself, the United States military is very different from Women for True Equality due to the fact that they had come onto the campuses of the law schools in FAIR in regards to gaining willful employees to join the United States military. The second fact is a temporal argument in regards to the fact that with the United States military coming onto the campus to recruit these students, at the end of the day, they packed up and they left and went home. Regardless, if Women for True Equality is allowed to come onto the campus, they will exist hypothetically forever within the campus until they break a rule and they are dismissed, Your Honors.
But unlike Boy Scouts and Hurley, the university has an opportunity to affirmatively disassociate itself with the views of its groups, unlike, for example, Hurley and Boy Scouts. What would you say to that argument?
Yes, Your Honor. Due to the fact that within Hurley and Boy Scouts, there are 2 points to be made. First, those were places of public accommodation, and secondly, those were both private organizations in a sense, Your Honor. But with that being said, the message itself of the university can be split into 2 pieces.
Can I ask you something? Because, I mean, it seems to me that the university as a campus is a place where you're going to have on a pretty regular basis, groups advocating for certain things, right? They're going to march and they're going to protest and they're going to advocate for something, right? So if we look at W2E, let's take for a moment, to take out of the equation the fact that they didn't let men join. Would you now agree with me that this is a group that has a First Amendment right to advocate for its position on campus?
Your Honor, the fact that now men have been taken out of the equation, they may come onto campus and equate their point, as you have stated, but as the petitioner has conceded to the fact that this is a limited public forum, and within the limited public forum, the message expressed by the university and the purpose is one of diversity and anti-discrimination.
Well, let me ask you this. Suppose that we were to find that the coffee shop is in fact not a limited public forum. Suppose we were to find that the coffee shop is an open public forum. Would that now not cause a problem for the university?
Your Honor, I can answer that question in two ways. First, the actual purpose, if it was to be found an open public forum for the coffee shop, is to sell coffee as a business, Your Honor. But secondly, that would not pose an issue to the case at this point in time, due to the fact that Olympus State University holds to the fact that within a limited public forum, there is a purpose to be expressed, and Women for True Equality has violated this purpose of anti-discrimination, Your Honor. And with that being said, the two parts must be split. In regards to first, the policy which governs associations, the anti-discrimination policy, in the Honor Code itself, which Sidney Kirsch was actually expelled under.
I want to get to the actual discrimination. If WT were, if they were to have men join the group, wouldn't that essentially kill their purpose?
Absolutely not, Your Honor. To provide an example, the NAACP specifically deals with colored persons' rights and things of that nature.
Counsel, is this within the record?
Absolutely not, Your Honor. I was providing an example to answer the question.
Okay.
The fact being that within its history, it has included white members in the essence that they have actually strengthened the message of NAACP, and the same can be said for Women for True Equality, specifically because these 5 men support the message profusely, and their inclusion will strengthen that message, Your Honor.
Yes, but that, not to pick on your NAACP example, that again sounds like Roberts. The USJC's message is to further the political and business aspirations of men. Arguably, women don't necessarily impinge on that message.
Your Honor, one distinction to be made between Roberts versus United States JCs was the fact that women were already included within the group JCs. So that can actually be distinguished from the case of Barr, that men have never been allowed to be included within Women for Equality.
With that example, I mean, the NAACP wouldn't qualify as an intimate group, but wouldn't WT qualify as an intimate group, considering they only had 100 members? Which started out with 5.
Your Honor, the respondent would respectfully disagree for 2 key reasons. First, all cases that have been provided within the case at bar deal with an analysis of place of public accommodation in regards to an intimate associative group, such as Roberts versus United States JCs, New York State Club Association versus New York City, and Boy Scouts versus Dale. But secondly, there are 3 specific characteristics cited within JCs that make a group an intimate associational group, and that is size, specific purpose, and selectivity. Now, the size of the group at this point is 100, as you affirmed, Your Honor. But that being said, the actual recruitment of the members at this point in time is person-to-person distribution of flyers, email. They have a student website in regards to Women for True Equality. So these numbers in a 64 to 36% setting at this point in time are going to increase, Your Honor, which leads into the purpose itself. The petitioner asserted that the purpose is cited within the Constitution and in that he has erred. The actual purpose is cited on page 5 of the facts, Your Honors, and that's to oppose the program as well as persuade the university. Now, that is a public-minded purpose.
Yes, but the purpose in the Boy Scouts is to teach young men about honesty and civil responsibility. The part of the moral code includes a provision about homosexuality. Isn't that analogous to this case?
It is not analogous to this case, Your Honor, due to the fact that within Boy Scouts there was an expressive associational evaluation, and that's what the court found within that case, whereas Your Honor had mentioned about an intimate associational group, and that is the question that I'm answering at this time. Now, back to your question, Your Honor, in regards to the actual purpose, the purpose is a public-minded purpose. And finally, the selectivity. Ms. Sidney Kirsch has opened up the floodgates of selectivity in regards to all women, regardless of view, person-to-person flyers, website. There is not an intimate selective basis here. In regards to that, for these aforementioned reasons, we respectfully request that this court affirm the ruling of the 14th Circuit Court. Thank you.
Thank you, Mr. Gomez. Mr. Manning?
1 second, Your Honor. I'm waiting for the timekeeper.
Sure.
May it please the Court? To address opposing counsel's statements regarding the 14th Amendment, opposing counsel did not address two key flaws in the university's stances, and that is first, that the university stated in the record that they were seeking a gender balance. A gender balance does not say the university is seeking overall diversity, but they're seeking to balance the genders to a 50-50 ratio. And this court has not held that quotas are constitutional. Additionally,
I think that your opposing counsel pretty clearly stated that the compelling interest was diversity, not based on gender, just diversity as a whole.
Your Honor, we would respectfully disagree. Opposing counsel may have made the statement in front of this court. However, that is created in response to litigation. The record demonstrates their statements before litigation was that they were seeking a gender balance. And this court has never held that strict balancing is constitutional. Additionally, this court has stated in the Grutter case that a university must exhaust opportunities that are neutral, race neutral in that instance, before they enact such a program.
Well, all it says is they must consider them in good faith. Whether they actually exhaust them all is not a requirement, even under strict scrutiny.
Yes, Your Honor. We would not require them to exhaust infinite amounts of efforts. However, if we look at the case at bar, the efforts by the university where they gave out baseball hats and tickets to male students only. There was no equal gender opportunity in these opportunities. Additionally, if we look at the facts regarding statistics and applications to universities, 43% of all applicants to universities in the nation are male. At Olympus State University, they have accepted 36%. Now, if Olympus State University accepted every male applicant, which would show that this policy is unconstitutional, there are still only 7% behind national application rates.
Counsel, can you respond to respondent's point regarding what the definition of a critical mass is?
Yes, Your Honor. This court has given deference to the university to establish a critical mass in their view. However, deference is not unlimited, as opposing counsel stated that the university has the right to establish.
My question is, what is a critical mass?
The critical mass, Your Honor, would be established by a university. In my view, it would compose a diverse class that would further the educational benefits of the university.
On what do you draw your view?
The holdings of this court that a diverse class would further the education, and that once that diversity has been met, the program has reached its limit. In the case at bar, that has been met. The university is only 7% below national application rates, and that's with full acceptance.
There's something about your answer I didn't understand. The answer to the question was that it would further education?
It would further the educational benefits of the students. The diverse class benefits all students. And in the Grutter case, additionally, the court stated that the students of the majority had not been exposed to the views of the students of the minority. But in the case at bar, it's males and females. And if we also look at the fact pattern, females have always been exposed to relationships with other male students. May I briefly conclude, Your Honor?
Just briefly, please.
Yes. As Your Honor stated, some females may attend a single-sex high school or lower education. However, that does not mean just because they attended one university that the rest of their lives contain no exposure, and additionally, that would be the minority, not the majority. For these reasons, we ask this court to reverse the decision of the lower court. Thank you.
Thank you, Mr. Manning.
Thank you.
Okay, guys, I'll make this as quick as possible. I'm not going to go through individualized feedback. You've heard me talk longer than maybe some of you have talked today. Let me just say everybody did an excellent job. We were very impressed. Very close ballots. This year's regional champion is the respondents.
We have some awards to give out. And so our regional finalists and runners-up, Gianni Cremeri and William Manning of Bethel University.
getting our champions.